In a pretty big blow to former President Donald Trump this afternoon, the D.C. Circuit Court of Appeals has denied his request to rehear his appeal of the gag order imposed on him by Judge Tanya Chutkan in the federal election interference case. The appeal was automatically denied after not a single judge requested a vote on Trump's motion. His only hope now is to appeal to the Supreme Court. We're still waiting to hear from that same appeals court on Trump's claim of presidential immunity in that case as well. But joining us now to explain it all is former top official with the Justice Department and MSNBC legal analyst, Andrew Weissmann. Andrew, thank you so much for being here with me on Election Day. I just wanted to start with the fact that not a single judge requested a vote, which feels to a non-lawyer like me significant. But what does that tell you about the weakness of the case, about Trump's clear potential desire to try to get the Supreme Court to take this case up?
Sure. Well, this, having just watched you and Claire, this might be the legal equivalent of her analogy to the bus and the dog, because this is basically...
Keep it going.
Yeah, exactly. This is, he lost the first time around by a panel of D.C. judges. That's 3 judges. And as is his right, he asked whether the full court of 11 full-time sitting judges would hear it, and they said no. The fact that no one of the judges asked for a vote to record, how the vote went doesn't necessarily mean that it was unanimous, but it definitely is a sign of the weakness of the case. It could be that one of those judges who didn't necessarily agree with the decision understood that there were not enough votes and there was no reason to have a vote. It also could be because of their concern about security. It's very well known that Judge Chutkan has been threatened, and in fact, someone has been charged with threatening her life. And so there was no need to sort of name names and for them to all stand together. But it isn't a good sign for Donald Trump that there wasn't anybody who was willing to say, we disagree with this, we want to vote, we do want people to put their names to it. I don't think that this is one where the Supreme Court's going to hear it. They have enough on their plate coming from Donald Trump. Yeah. They're about to have oral argument on February 8th in connection with the Colorado case about whether he's qualified or not qualified to appear on the Colorado ballot.
I mean, they do have a full docket, I think it's fair to say, of Trump things. I never thought of the concern of the threat, but given the rise in swatting against people in the judiciary, that certainly makes sense. It's an interesting point. Well, while we have you, I did want to ask you about the immunity case, because we're still waiting also for a ruling from this same court. Do we have any sense of when that might come or what we can expect on that front?
Well, Mary and I on our podcast have, actually said we thought it would have come out by now. So, no one knows when it's going to come out. But, our betting is that it's any day now. Remember, they, like the Supreme Court, they have expedited hearing on this case because the judicial system is trying to sort of catch up and be giving decisions in real time, understanding that there's sort of a unique threat posed by Donald Trump on so many different fronts. There's so many legal issues that he is sort of throwing out, whether it's the Colorado case, whether it's immunity, whether it's the gag order. And so they expedited hearing this case. So it's hard to imagine that they expedited hearing the case, had briefs coming in over the Christmas and New Year holidays, and then they're going to sit on this. If I had to guess as to why it's taken a couple weeks, it's because it's not one judge who is ruling, it's 3. And that means that there's coordination. They may be wanting to make sure that they can reach unanimity on certain issues. And so that, I think, is a factor that people should take into account.